Welcome to the Rounds, FCA News with Tejinder Singh. I'm Scott Oswald. I'm chair of the Ketam section of the Federal Bar Association. We created the Rounds as a recap of recent case law developments in the False Claims Act arena. Will be available to members of the Ketam section about once every other month to provide Tejinder's thoughts and insight on some most relevant recent case law developments. Tejinder, hello.
Hey, Scott. Good to see you. So glad to be here. Kick this off with you.
It's going to be a lot of fun. So we're going to go through just a few case law updates on cases that you've identified, and then we'll take a deep dive on one of those cases. How's that sound?
Sounds perfect. Let's do it.
Terrific. So let's talk about Integra Analytics. Just tell us a little bit about the case, where it ended up, and maybe just a little summary.
Yeah, this is one of a few cases brought by a healthcare analytics company, or you'd say maybe a data miner. And what they've done is they've looked through the way that different healthcare providers are coding for certain services and found examples of outliers. Now, this is something that the Department of Justice also does when they're doing their own fraud enforcement. So Integra is kind of copying that approach and then doing a little bit of further investigation to see, are these outliers examples of fraud? And they brought complaints against healthcare providers around the country. And this case got a lot of press earlier because it was teed up as this question about the public disclosure bar, about whether everything on the internet is the news media. And when the Ninth Circuit got its hands on the case, it decided it didn't want to touch that question at all, and instead got rid of the case on a totally different ground, which is that the defendant, maybe they were just really good at coding, and so maybe the fraud allegations aren't plausible. And that was the basis for the holding in the Ninth Circuit. And so now the case has been dismissed, and the relator has actually filed a petition seeking rehearing en banc. As we talk about this, we'll see if that's granted or not. But that's kind of the state of play. And it's an interesting decision for what it says for outside relators in general.
So the thing that struck me almost immediately when I looked at it was dismissed on Rule 8 grounds, right? And I'm thinking, gee, am I reading the wrong case here? Talk to us a little bit about that.
So the Supreme Court decided these cases, Twombly and Iqbal, where it really put more meat on the Rule 8 bones. And ever since then, defendants have had a shot at winning dismissal on Rule 8 grounds. And one of the things that the court said in Twombly was, if there's an obvious alternative explanation that isn't culpable, then maybe the defendant can win dismissal at the pleading stage. Maybe the allegations aren't plausible enough to survive Rule 8. And that's what happens in this case. The Ninth Circuit says there's a plausible alternative explanation here, which is that maybe their defendants are just really good at coding. Maybe they're ahead of the curve, doing this better than everybody else. And so unless you can rule that out, you haven't alleged fraud. Now that seems to be like an enhancement of the Twombly standard, as opposed to just sort of parroting it, requiring you to rule out other plausible explanations. There's actually precedent in the Ninth Circuit and several other courts of appeals that says that's not the law. You don't have to rule out all the other explanations. You just have to offer one plausible explanation of your own. But here, the Ninth Circuit takes it a step farther. It's in an unpublished decision, so I don't know how far it will go. But if it were in a published decision, this would be a big deal in Twombly land.
So let's talk about the implications of this. I mean, both kind of in terms of the pleading standard, and then what does it say for outside data miners? Should they be concerned?
I think everybody ought to be concerned when you see a case like this. The pleading standards some courts have been trying to slowly ratchet them up and ratchet them up and ratchet them up and make it harder and harder for cases to even get into the discovery part of the inquiry. And that's really a major challenge to fraud enforcement, because so much of what makes fraud happens behind the scenes. And so getting the ability to spot outliers and proceed is, I think, really important. And as I noted, this is how the government does their enforcement too. And so I think it's a threat to outsiders, of course, who are going to be relying a lot on the data to figure out, is there fraud and is there a case worth bringing? But it's also going to be a threat to others as well, because you're going to see examples of where the defendant can kind of just throw something against the wall, like, hey, maybe it's not fraud. And then all of a sudden the plaintiff has to say, well, no, it definitely is fraud at the pleading stage. That's going to be really complicated. So, the one piece of solace here is that this is an unpublished decision and it's not clear how far it will go. But if people start citing this, if lower courts start citing this a lot, I think it would be a real cause for concern.
Let's move to our second case, the U.S. X-Rail Dan Abrams Company versus Medtronic here. Tell us a little bit about this case.
This is a case about reimbursement for medical devices. And the case is interesting only really for one narrow reason, which is that the Ninth Circuit panel in this case seems to deliberately be trying to undermine its own precedent without saying so. So in this case, there was an FDA approval for certain medical devices. And what the relator alleges is that, look, for some of these devices, the way that they're designed and built, they can only be used for uses that are contraindicated by the FDA. There is no viable use for these things that's been FDA approved. And the relator says, therefore, any claim based on those uses has to be false. There's precedent in the Ninth Circuit that says when you violate FDA approvals or obtain FDA approvals by fraud, the claims become false. That's a case called Campy that actually I argued and I feel very protective of. And in this case, the Ninth Circuit says, you know, the defendant says that we shouldn't talk about FDA approval in the context of the False Claims Act. They tried to extend this case called Buckman, which says you couldn't have a novel common law fraud on the FDA claim. And they say, but here in the Ninth Circuit, Campy rejects that theory, that Supreme Court precedent. And the First Circuit seems to have accepted it. So, you know, do what you want with that. And so the Ninth Circuit seems to have said, here's a circuit split, and here our decisions don't seem to jive with Supreme Court precedent, but let's, you know, see what the defendant wants to make of that. And they just put like a paragraph in their own opinion there, which sort of takes a shot at their own precedent, which is an odd thing.
They seem to be just teeing it up for maybe a petition for certiorari.
Either a hearing en banc or certiorari. I think certiorari is the more probable candidate, you know, just kind of giving some ammunition to the defendant to seek review if they want to. The attempt should fail, to be clear, because the one paragraph characterization in the Ninth Circuit's opinion about what the First Circuit has done with Buckman is not correct. There have been First Circuit cases that have allowed medical device cases to go forward. So it's a bit of an odd thing, and I don't know if it'll actually go anywhere, but it was really jarring to read because you don't often see a panel just say, yeah, we have this circuit precedent. It seems, you know, weird, but whatever, you know, the defendant loses. That's an unusual way to do law without even attempting to defend your own circuit's precedent. So, you know, we'll see if it goes anywhere, but they've teed it up for sure.
So one of the things that they discuss is what you mentioned, the fraud on the FDA theory. What is it?
Fraud on the FDA is exactly what it sounds like. The notion is usually that somebody has deceived the FDA into approving a device, perhaps, or a drug. Perhaps they concealed relevant safety data or clinical data. Perhaps they misrepresented the efficacy or the safety in some other way of the device. Perhaps they misrepresented how similar it is to other devices on the market. There are any number of lies you can tell to the government to get it to approve your drug or medical device. And so a fraud on the FDA claim would be, you did that, you got this approval by fraud, and then you started marketing the device and getting payment for the device. And that upstream fraud has tainted those claims for payment. Another way this sometimes comes up is in the off-label context. So the FDA approves drugs and devices for particular uses, and then you go off and you market them for some other use. It's not exactly fraud on the FDA, but it does also sometimes make the claims false. And that's a complicated area of the law, but intersects with this one substantially.
What do you think? Are they likely to get en banc review?
I don't think so. I mean, as I said, I don't think there is actually a circuit conflict between the Ninth Circuit and the First Circuit. I think the panel was kind of just splatting one against the wall to see if the defendant wanted it. It was sort of like an attempted alley-oop, but this would be like the video where the guy goes for the dunk and just misses the rim. I don't think it's really close. But, you know, I've been wrong before, so we'll have to see.
Okay, let's check in on our third case that you've identified, Felten versus Beaumont hospitals. And this is a case under the employee protection or anti-retaliation provisions of the Federal False Claims Act.
Yeah, this case does raise a real circuit split. So the question in this case, there's a physician who brought a claim, a retaliation claim against his former hospital. And he says that after he filed a complaint under the False Claims Act, he was retaliated against effectively by being blacklisted He said he has applied for jobs at 40 other institutions subsequent to that and hasn't been able to get one. And that he's basically unemployable now as a result of his whistleblowing activity. And in this case, the question that came to the Sixth Circuit was, does the word employee in the False Claims Act mean also former employees? And the Sixth Circuit says that the answer is yes. It relied on two things. It relied on a Supreme Court case called Robinson versus Shell Oil, which said that the word employee in Title VII of the Civil Rights Act included former employees. And it relied on its sense that the False Claims Act really seems designed to protect people from retaliation, including blacklisting. And that's exactly what happened here. A variety of other courts, including the 10th Circuit Court of Appeals, have said that employees don't include former employees. And so now there is a real but shallow circuit conflict on this question. And you could potentially see the question going farther.
You know, when I was looking at the opinion, my first thought was, boy, this was pled well. 40 different positions that, you know, he didn't even get a call back on. I thought, boy, that was well crafted.
Oh, for sure. I mean, I think when you're thinking about a case like this, you know, you do need to make it as palpable as possible. And yet it shouldn't be that hard, right, in the False Claims Act context, because this kind of blacklisting is, I think, the number one complaint relators have, right? I mean, sometimes relators are obviously retaliated against at their current job, but I think one of the big concerns potential whistleblowers have before they blow the whistle is, am I even going to be able to find employment in my industry after I do this? Or will I have a reputation, you know, as a whistleblower? Will my current employer go out and ruin my reputation? And so, yeah, I think it was pled well, but I think it's also quite indicative of what actually goes on in the market.
Employees who are coming forward and blow the whistle now, at least they have in the Sixth Circuit, right? They have some protections from that employer reaching out and potentially retaliate, right?
Absolutely. I mean, this has provided False Claims Act protection where there was none before. And so I think that is quite helpful to those employees, ought to be reassuring to them. And then the hope, of course, would be that a decision like this catches on and continues to provide that kind of protection, because I think the Sixth Circuit's understanding of the statutory purpose is quite correct. You know, I think this would be, if you asked the folks who wrote it, I'm sure they would think, yeah, we want to stop that. It does strike me as a decision that is correct, given the disagreement in the courts. There's a debate to be had, but I think on balance, it's correct. And it's very good public policy.
In the opinion itself, it talked about the fact that employed could embrace the concept of was employed. The dissent seemed to make a lot of the fact that it just says employed. I thought that was an interesting contrast between the two that were in the majority and the dissent. What do you think?
Yeah, I think that's right. And then I think the other major sticking point between the majority and the dissenting opinions is there's this phrase in the False Claims Act retaliation provision that says you have to be discriminated against in the terms and conditions of employment. That phrase is lacking in Title VII. And so there's a contrast between the statutory text that the dissent made a really big deal out of. But the majority just sort of said, look, no, you know, there are lots of terms and conditions of employment that can persist after you leave. Give examples like severance or retirement benefits, for example. And so it said we aren't really sure that, you know, that phrase means anything. But there's a lot of textual jousting as between the majority and the dissent, which I think is really interesting for people who are students of statutory interpretation. There's also a really interesting debate about, you know, how Robinson, the Supreme Court case, controls or doesn't control this one.
So what do you think about here? This may very well be a candidate for Supreme Court review.
I think it could. So 1-to-1 circuit splits are what we call shallow circuit splits, and they don't always go up. There's lots of times where the Supreme Court is happy to kind of just let those things bubble around and see if the lower courts arrive at a new consensus on their own. On the other hand, it is a real circuit split. Two courts of appeals have disagreed, and the court may think that it's worth taking up. It would depend, I think, on the strength of the remainder of the candidates for certiorari review. But this is the type of case that certainly could go up if the court was looking for something to take.
So let's now turn to a case we're going to spend just a little more time on, U.S. versus Strock. Tell us a little about this case out of the Second Circuit.
The Strock case is a really, really weird case. This is a case involving contracting preferences for service-disabled, veteran-owned small businesses. And these preferences require the government in certain cases to award contracts without full competitive bidding to small businesses owned by service-disabled veterans, as the name suggests. And the scam in these cases, there's a few of them, but the one at issue here is a business that doesn't qualify for these preferences hires a service-disabled veteran and says, okay, we're going to pretend that you run the company now. We're going to bid for these contracts that you can get and we can't get. We're going to give you a little bit of money and we're going to keep the vast majority of the money. And everyone's happy. And this hurts the government because the government doesn't get the benefit of competitive bidding, because actual service-disabled veterans and other minority-owned businesses don't get a fair shot at these contracts. So there's lots of reasons why it's bad. And the government has undertaken to enforce against this. There's been criminal enforcement, there's been civil enforcement, but it happens a lot. And sometimes it happens where the government's contracting officers may know, but they just kind of don't really care or don't really understand the requirements. And so this was a case where this happened, where the government tried to stop this under the False Claims Act, and then the district court threw it out on, of all grounds, materiality, saying, you know, I'm not sure the government actually cares about this, even though the government had brought the lawsuit. And that led to an appeal in the Second Circuit.
So what did the Second Circuit have to say?
The Second Circuit reaches the right result, but it does so in a way that is just utterly baffling to me. I have to admit, I do not understand this decision. So the Second Circuit says, yes, there's enough here to plead materiality. And what we're going to base that on is we'll base it on the fact that, you know, under the program, this is structured as a condition of eligibility for getting the contracts. And we've seen some of this past enforcement. But the really interesting part of the Second Circuit's decision is it has this discussion of, okay, in order to be material, it has to be material to the government's payment decision. What is the payment decision? The government had said, in this case, what we're talking about is a fraudulent attempt to get a contract from the government. And so the relevant payment decision is whether we do the contract or don't do the contract. And this requirement that you be a genuine service-disabled, veteran-owned small business is clearly material to whether we give you a contract set aside for those businesses or not. We would never do it otherwise. The defendant says, no, it's not. It doesn't matter whether it's material to the contracting decision. It's only whether it's material to your decisions to make payments under the contract. So you have to show government that you would have cut off the payments right away once you found out about this in order for it to be material. And the Second Circuit does this odd baby splitting exercise where it says, actually, neither of you are right, it's both. The reason this is so weird is that I do not know what that means. So imagine two hypotheticals. In one hypothetical, it is material to the decision to award the contract, but not material to subsequent payment decisions. Does the government win or does the government not win? I don't know. In hypothetical number two, it's not material to the decision to award the contract, but it is material to the subsequent payment decisions. Does the government win or not win? I still don't know. It's a really weird decision because it sort of says no one's right, both are right, and then doesn't tell you how to work with the variables when they don't line up. In this case, it doesn't matter because they both line up. The government showed that it was material both at the time of contracting and at the time of payment. But like, is that what the government has to win now? Do they have to win both? And if so, how is that the middle ground, right? Why isn't that just the defendant wins everything? It's a really weird decision.
It seems like what they've done is they've just increased the government's burden here, right?
Maybe, or maybe they did the opposite. Maybe what they actually said was that the government can win either. You cannot tell from the face of the Second Circuit's decision what rule they were trying to adopt because the language suggests, you're both wrong. The answer is somewhere in the middle, but there is nothing in the middle, right? The only thing it could be is you can win either, or you must win both. Those are the only options. And I don't know which one is right. And you can't figure it out reading the Second Circuit's decision.
So let's talk about the implications of this. The SBA is now responsible for administering a program. I mean, it dwarfs the amount of money that it ever had before. What does this mean for the CARES Act programs that are going through the SBA?
I think it means a lot. I think obviously trillions of dollars have been pumped into the economy, hundreds of billions of it through SBA programs. And we're looking at situations where there's going to be initial decisions to give money. So for example, in the PPP context, decisions to make loans. Then there's going to be subsequent decisions to forgive those loans. And you're going to be asking the materiality question. And Strock sort of raises this question about, well, when do you look at the decision, which decision matters? Do they all matter? And how do they interact with each other? You don't really know. So it's going to raise some questions. I do think this decision is most relevant, though, to government contracting. And not just SBA contracting, but contracting sort of overall, because it raises this materiality question about different points in time. But, you know, as far as the SBA programs go, one real concern that I think a lot of people have expressed is that the SBA seems a little bit overwhelmed. It seems like there's a lot of money getting put into the economy, and the policy priority is get the money out, get it deployed, get it working, get it stimulating. And then when the government goes to claw it back, when it's been taken fraudulently, there's a real worry that, oh, was that initial push to get the money out, is that going to undermine materiality arguments down the line? And I think there has been some guidance from the government that sort of tries to push back and preempt that and say, no, we really do care. But courts are going to have to credit that. And there's a question about whether judges like the judge in the Strock case are going to.
You know, a good example is the SBA has said we're not going to audit any loans under that $2 million level. What do you think that's going to do for civil enforcement under the False Claims Act for those loans, let's say, where the government does decide to proceed?
Yeah, I think that's going to be a real challenge. So, you know, on the one hand, I think you will have seen there will have been some criminal cases, even involving relatively smaller loans, which might point in the right direction. But when you look at certain other requirements, so in addition to saying they weren't going to audit loans under 2 million, I believe at one point they were saying, I don't know if they're still saying, that anyone who borrowed less than 2 million would be deemed to have certified their necessity in good faith. Right? So just like a get out, even if you didn't need it, you're deemed, which that I think is, it's a tremendous problem for enforcement. You can't have a case based on necessity, I don't think, if someone's deemed to have, said so in good faith. So I think that there's a substantial set of challenges there. On the other hand, they have made it quite clear, we do care about this. We do want the money to go to places where it's actually going to help. And so for other requirements, I think that the criteria may still have some bite. But we're sort of just seeing now the first wave of civil cases, I think, working their way through U.S. attorneys' offices. And it's still kind of anybody's game where these go.
So let's talk about Strock in the government contracting space. How does this affect False Claims Act cases under the procurement theory? Again,
that kind of remains to be seen because we've got this ambiguity about what the decision really means. I think what you're seeing here in part is the continuing ongoing effects of the Supreme Court's Escobar decision sort of metastasizing. So, everyone who's watching this probably knows everything there is to know about Escobar now, since it's been discussed in like 5,000 panels. But the case said, we care about payment decisions. That phrase, payment decisions, is not in the statute. It's just what the Supreme Court used as its shorthand to try and figure out when regulatory violations could give rise to false claims. And here the Second Circuit takes that phrase and they sort of pretend it's really important. They pretend it's like statutory language. They try to figure out, well, how can we apply it to this discrete context of government contracting? And there was no reason to do that, right? None whatsoever. And so it's created this ambiguity where I think previously there was none. I think previously the government's view was the prevailing view, that if you scam your way into a contract, the False Claims Act applies. And so now there's this new ambiguity. I'm hopeful that it will sort of settle. just kind of how materiality under Escobar generally has settled in a more sensible place than people thought it would be originally. But it's a new open question.
So as a Supreme Court litigator yourself, when you look at the opinion and it cites over and over again some of the Justice Thomas's words, what's your inner voice telling you then?
This is just a common problem with lower courts interpreting higher courts' precedents. District courts do it with circuit court precedent. Circuit courts do it with Supreme Court precedent all the time. They pretend that every single word and syllable of the higher court's opinion is, gospel that must be obeyed. And I'll tell you, this is not how the Supreme Court writes decisions. So one thing that people who don't practice at the Supreme Court don't know as much is when an opinion gets written, the justices do not generally line at each other's opinions at all. There's some high-level feedback given in memos back and forth about the holding and similar, but they're not going through and making sure that every sentence is exactly what they agree with. And that's why you'll often see Supreme Court decisions that seem to be inconsistent with each other when they're written by different justices. It's because each individual justice kind of had something different in mind when they were writing something, and they're not fly-specking each other. And you can see why they wouldn't do that, right? Because if you had 9 justices trying to write by committee, no opinions would get written, and all opinions would be a total mess. So that's why they're pretty deferential to each other. But the flip side to that is, you can't put too much stock into the individual phrasing choices of a Supreme Court decision if what you're trying to do is predict what the Supreme Court is going to do next. And so one thing that's kind of frustrating is that sometimes lower courts lose sight of that, and they pick up on a phrase, a word, and it becomes the whole ballgame in a series of cases. And I think that that's kind of what you saw in the Strock decision. And I think over time, hopefully, it will smooth out, but it's also possible that other people will hook onto that and make it a thing. And we'll need to keep discussing it.
Well, Tejinder, thank you. This has been fun.
Yeah, I'm having fun.
We look forward to seeing you for the next installment of the rounds. That'll be in about 2 months. If you have any cases you'd like us to cover, any concepts you'd like us to address, email me. We'll put it on the list. We look forward to seeing you in 2 months for the rounds, FCA News with Tejinder Singh.